why this webinar series come through and just let every participant know the reason behind it. It's part of ciarb's learning and development and part of our vision to educate, transform, and create awareness regarding dispute resolution mechanisms. That it's a whole spectrum where you have the choice to choose it in your civil and commercial disputes. And today's topic specifically deals with why arbitration is that mechanism, and then what challenges we face in enforcing or in challenging arbitral awards. So the panelist today we have is Dr. Laura Lintott. You may have already seen from when you were doing the event registration. Laura is a counsel at Watson, Farley and Williams LLP. She's a visiting fellow of where I'm an alumni from, King's College London, and she teaches on the Construction Law and Dispute Resolution MSc program and supervises undergraduates in land and private law at the University of Cambridge. So Laura has done amazing stuff. I mean, most recent is she has been a co-author of the 150 years of the TCC, the Technology, Commercial and Construction Code. And here we go. That's the book, the history of the code, how the code was formed. And I was lucky enough to be in the company when the book was launched with amazing co-authors, basically all the heavy hitters. So that was amazing. So thank you, Laura, for joining us. Then we've Abdul Majid Khan, Chief Legal Officer, CPPAG. I mean, if from someone's perspective, my personal view is there is no one more experienced in arbitration, both domestic and international, than Majid, because of his background, his experience in power sector, infrastructure, project development, financing, and the amount of LCIA and ICC arbitrations that you've undertaken. I think I can easily say there is no one else there in Pakistan but yourself. So really amazing and really graced by your presence and with your experience. I think we have a lot to learn from. And our third panelist is Sheikh Muhammad Ali, who's a managing partner at Rasik Concilium with 25 years experience. He's also a member of ciarb as well and has been doing amazing stuff in domestic and international arbitration, specifically in transmission, distribution, electric power, and the general, power sector, power purchase agreement disputes. And he has tremendous experience both in arbitration, in litigation, both from the perspective of enforcing an arbitration and resisting an arbitration. So getting his views on this give us a different perspective. So while we're waiting, I'll just start with my initial thoughts. And those are, over the last couple of decades, the explosive and continuous growth in cross-border trade and investments, it has jet propelled the growth of international arbitration. As we know, we see more and more in the news, and when we look at it today, in terms of arbitration, whether it's ad hoc, institutional, whether it's domestic or international, it is the universal first choice over transnational litigation for the resolution of cross-border business disputes. And as I mentioned, in certain jurisdictions, even for domestic disputes, arbitration is the most prominent form of dispute resolution mechanism over litigation. So why parties choose arbitration for international disputes? So there are several reasons that have remained constant. And I've read the Global Arbitration Review Guide to Challenging and Enforcing Arbitration Awards, and there are two reasons that probably outweigh all others, and those reasons are that the first one is there is a widespread reluctance of international parties to entrust the resolution of prospective disputes to the national court system, of their foreign counterparties. And then this unwillingness to trust foreign courts, whether based on knowledge, whether based on uncertainty, whatever it is, actual or apparent bias, it leaves international arbitration as the only realistic alternative, assuming that the parties have equal bargaining power. Now, the second one, unlike court judgments, arbitral awards benefit from a series of international treaties. So if a party wants to get their award enforced against another international party, they can go and enforce it in any other country. And that is through the New York Convention of 1958. And as of today, I checked it this morning, there is 172 states that have signed up to the New York Convention. That is astonishing. If you look at it, under United Nations, there are 196. I don't know about the other 24. Maybe there are microstates or small entities, so not signed up. But then there is another thing. If the enforcement is against a sovereign state, the Convention on the Settlement of Investment Disputes between States and Nationals or other states of 1966 requires that ICSID awards are also to be treated as final judgments. And as of today, it's 163 countries who have signed up to ICSID as well. So that gives arbitration that prominence. Now, moving on to the panel discussion today with our amazing panelists here, to discuss the practicalities of arbitration awards, both in terms of enforcement and challenging it, both in Pakistan and internationally. So my first point, Majid Khan, I will come to you from your experience perspective as being so experienced in both domestic and international arbitration perspective. What are you seeing as soon as you're getting towards or closer to an award? What is happening in Pakistan at the moment?
First of all, thank you for this opportunity and the invite. I was just coordinating with Mr. Sheikh Muhammad Ali. He is trying to connect, but somehow he's being unable to do that. So if you can just send him a new invite,
I'll do that.
maybe he'll be able to join us. Well, sorry. The question was that, sorry, can you repeat the question?
So the question again, as we discussed, is your perspective from an arbitration award perspective. You've you've worked through the whole arbitration. It may have taken 2 years, 18 months. Where do you go now? What happens?
Well, to begin with, I would first like to say that uh, in the past almost 10 years, um I've been involved in more than 20 arbitrations. Most of them were under LCIA and a couple of them were under the ICC. Well, the main, I would say, um, issue that we normally face is that the best thing for us, the interest that we have in arbitration is that we know what the dispute is between the parties, and then we want to have it resolved as soon as possible. So we have about more than 120 of our projects operating in Pakistan. And in all of them, we have this international arbitration clause, majority of them under the LCIA, and the older plants, older projects, they have the ICC. And when there's a dispute between the parties, there's a long um, list of issues, and the stakes are too high for both of us. So what we want is to have a resolution or of the dispute as soon as possible. And if we go into the courts, like for the dispute, it can take a very long time, and then there's a long way, and we cannot really wait for that. And because both the parties suffer a lot during that time. So the arbitration is when we know that, okay, through this arbitration, we have a time frame. It can be between 12 months to 24 months, but we know that at the end of the day, we're going to have something, a, a decision, an award, which can be then, which will be in favor of somebody, both of the either party, and then we can take it up to the court for the enforcement. And that is where bit of a problem again starts, because our judicial system, our court system, once you file for the enforcement, then you have a lot of steps to take and bridges to cross to finally have that award enforced. So, but still, that is, arbitration is a preferred mode of dispute resolution that we go through.
That's fantastic. Laura, I'll come to you on this point. From your perspective, where you are in an international jurisdiction perspective, and you have such wider experience in all these different elements, where do you see
Hello?
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 Um,
Hi, I didn't
so
know what
my
happened
my
there.
oh, don't worry. My question to you was, we've got an award. What happens next? Where are we going?
Yes, so I am an English lawyer. I focus on the jurisdictions of England and Wales, and so I'll give you always the perspective from that starting point. And of course, I'm also in international arbitration myself as a specialist. So we've got an award, and now we want to enforce it, right? So an award made by an arbitral tribunal pursuant to an arbitration agreement is immediately enforceable. And if unsuccessful party does not voluntarily comply with the award, it can happen where the entity that lost does not comply, then the winning party will want to enforce it. And enforcement means giving an award the same effect as a domestic court judgment, which then serves as the official basis of further execution. Where assets are located in other jurisdictions, which is very common in international arbitration, I strongly recommend you seek advice on local law from lawyers in that jurisdiction, which is very, very common. I mean, we have international law firms. I'm at an international law firm, and we can engage several of our offices for that purpose. And when there are assets in multiple jurisdictions, advice will need to be considered prior to enforcement and preferably prior to issuing the proceedings themselves. Then I would split it into two. You've got informal enforcement, so you can apply commercial pressure, diplomatic reputational pressure, or negotiating a reduction in payment due to costs that are saved, but not pursuing formal enforcement. And then you've got formal enforcement. Now, in England and Wales and Northern Ireland, we are governed by the Arbitration Act 1996, which is currently undergoing a slight gentle reform. The act is in good shape already, but the reform is always welcome after a quarter of a century. So there are three routes to formal enforcement under the Arbitration Act. One is that the Arbitration Act provides, so to speak. And the first one will take you what Nasir already mentioned, the New York Convention. The second one is seeking permission to enforce on a without notice basis. And the third one is bringing an action on the award for breach of implied term that the parties agreed to comply with the award when they signed the arbitration agreement. And that's a relatively new cause, and the limitation on this cause is 6 years. And I don't want to take too much time, Nasir. I mean, I could talk about this for ages. I could talk about in further detail the New York Convention. But what do you think? Are you happy with the answer?
Absolutely. I think it's fantastic because I think one of the things that we would like to know is the top tips to consider for successful enforcement of arbitration awards, and what do you think? What are the top tips for it?
Yeah, so the top tips, which are practical tips for successful enforcement of an arbitration award, are, first of all, consider where the seat of the arbitration award will be. Is it a signatory state of the New York Convention? Because we touched upon this earlier, that the New York Convention allows and includes the UK. Basically, the parties, the 172 signatories, agreed to enforce arbitration awards from other this is wonderful, but of course, not every country in the world is a member. So first of all, check that. Another second tip is consider where the debtor has or will have significant assets. Are these located in a New York Convention state or not? Because if not, then you may consider, are there any other conventions or any other ways of accessing those assets as part of the proceedings? And then consider whether a freezing order or other methods of preservation of assets is required in advance. And then consider formalities required in the award and the form of the award for enforcement purposes. And then, of course, last but not least, consider claiming post-award interest.
Brilliant. I mean, we've finally got Sheikh Muhammad Ali. We've done a massive introduction for you, Sheikh Saab, and I'm going to ask you, a question. I mean, when we were having this discussion, you pointed out the issues around domestic awards, and I'm going to ask you the domestic award question first. That domestic awards can be challenged on the grounds. The first one, let's do that, is the tribunal misconducted itself or the proceedings. Okay, so I'm going to just stick on this one. And the question to you is, based on the tribunal's misconduct, or wrongful appointment of the arbitrators, can the award be set aside?
Thank you very much, and I'm sorry first that I have been keeping you all awaited, and I hope you can hear me now. I'm really sorry because there was some proceeding further. Yes, of course. The Arbitration Act 1940 specifies major grounds. There are only three basic grounds on which an award can be set aside. And one of those three grounds is that where the arbitrator, or in case where an umpire has been appointed and he has misconducted himself or misconducted the process. And this, I believe, is a principle which is recognized even in the international conventions and other jurisdictions as well, that where the arbitrator is misconducting, or the umpire himself or the award is liable to be set aside.
Brilliant. So in your experience, if you want to say, give us some examples of where you have found this in Pakistan in domestic arbitration, and then we will ask about the same question to Majid Saab about his experience on both domestic and international arbitrations.
I knew one arbitration where a former chief engineer of railway was there, and he did not disclose the fact proceedings, advising the other party, even the railway party actually, that out of my experience, this should be your point and this is how you should present your case. And when this matter went up before the judge, he was not only astonished, but he was surprised. And he said that if he is the arbitrator and advising the party, so what is he doing? So he actually misconducted himself and everything. So that is how it happened.
So I'm coming towards you, Majid Khan Saab, and what's your view of this conduct of the arbitrator from the award perspective? How do you see this issue in terms of thinking about what to do with the award?
Well, in my experience, I've not participated in any local arbitration, but in one of the international arbitration under the LCIA, where in fact Sheikh Ali was representing us, we had an issue with the arbitrator because he was, well, appeared to be quite biased towards us. And we formally filed I think it was a complaint or a reference against him. And then it was referred to some other senior arbitrator. And at the end of the day, the observation was, yes, he seems a bit biased, but it's not that much a bias that he should be removed from this arbitration. I think, is that so, Ali? Do you remember that?
Yeah.
Yeah. So, and eventually, but that award was against us, and now, but the company went into enforcement, and I think we settled on that before it could be enforced. So, but
Brilliant.
you have these issues once in a while, but you have to face them and tackle them as they come along.
Absolutely. And I'm going to come to you, Laura, on this. Is there a duty of independence and impartiality for arbitrators? And what's the difference between independence or impartiality? Laura, you're mute.
Actually, has
Someone has to do that.
It's only because I don't like the sound of my own voice, Nasir. Apologies for that. So it's a very good question and a controversial one as well. So the ancestral model law requires both independence and impartiality. However, not the Arbitration Act 1996 in England and Wales. So the duty is to act under Section 33 to act fairly and impartially, but independence is not mentioned, or the independence of the arbitrators. Now, it's interesting because the Law Commission has issued 2 consultations at the end of this and start of at the end of last and start of this year. And they concern the potential reform of the Arbitration Act. And one of the issues is precisely this one that has been raised, whether independence should be codified as well as impartiality. Now, the issue is specifically in the construction industry that the pool of potential arbitrators is already quite small. And so while it's absolutely necessary for arbitrators to be impartial, the independence codification would restrict the choice of arbitrators to such an extent that it may be not even possible to appoint one. So this is, however, this is not just left at that, of course, because impartiality and independence are important. So here it is where the obligation of the arbitrators comes in, of disclosure of issues where they feel that the issues are relevant to the arbitration, to the case, and to their independence and impartiality. And of course, the parties can interview the arbitrator, they can review what the disclosures are, and if they are not happy, they need to say so, and a potentially different arbitrator will have to be selected. So that's how it's addressed at the moment. The question was raised then whether to codify independence, and I was part of the task force responding to the Law Commission's consultation together with Professor Renato Nazzini and his wonderful team. And our view was that we agree the impartiality should remain codified, but not so the independence, and stressing the importance of disclosure.
So that's the update to the Arbitration Act 1996 in the UK.
Yes.
And when I give you a reference, I'm sure you know what Arbitration Act in Pakistan is. It's the old Arbitration Act 1940, where there are no such references, there are no such practical implications, and a number of domestic arbitration in Pakistan are ad hoc, which are from that perspective just reviewing how the act applies to them. And this is where I'm going to come back to you, Ali. in terms of asking you that if there are no such provisions, then what are the grounds on which a local award is set aside?
Basically, there are two different aspects first, which I intend to continue first of all from Laura's point of view. Uh, and when you added that in Pakistan under the 40 Act, there is no element of impartiality and or independence of the arbitrator. Very interesting information is that under the law, High Court is to prepare and promulgate the rules. That if there is any deficiency in the act, that is supposed to be covered by those rules. Even those rules are silent on these aspects. So this is one thing which I must say. And the second thing is, despite this problem in the laws of Pakistan, I can assure that Pakistan Arbitration Act even is have the pro-enforcement bias tilted towards the arbitration, and therefore there are very limited grounds. There are very limited grounds to set aside an award. I explain it. The first thing first is the arbitrator's award is giving the sanctity. The process is takes some certain time. It's little apparent to be complicated. It's actually not. It's very simple. But since people are not here in Pakistan, the issue of capacity persists, and that is why there are some complications. Otherwise, it is very straightforward process. There is an award which has to be issued in 4 months or some extended time, and the court can either modify the award or pass a rule of court on the basis of the award. Less than that, the court can remit the award to the tribunal, and only 3 grounds can set aside an award. We have already discussed one of the grounds where the tribunal has misconducted himself or misconducted the proceedings. The other 2 grounds are where the award, where the arbitration was already superseded or had become invalid, and still the award was issued. In that case, the award is to be liable to be set aside because that proceeding has already been nullified. The last reason to set aside an award is that award was somehow procured in an invalid manner, or it was invalid for any other reason. So these are 3 major grounds, and I can compare it with New York Convention even. There are more grounds under the New York Convention to deny the recognition. So that is why I'm claiming that Arbitration Act 1940 is actually more in favor of the enforcement. So that is how the Pakistani law operates.
That's brilliant. Laura, I've a quick question to you. If we compare those grounds and how 1996 Act in UK courts, and Pakistan has been famously part of some of these enforcement challenges in the UK. So how do these compare in terms of the 1940 Act, the New York Convention, and what we have in the 1996 regime at the moment?
Yes, so I'm just going to touch on the challenges to enforcement, just carrying on from what was said already, but under the Arbitration Act. And so we have 3 main challenges possible. One is under the Section 67, which is substantive jurisdiction challenge. And it is defined in the Act by reference to whether there is a valid arbitration agreement, the tribunal is properly constituted, and the matters submitted to arbitration are in accordance with the arbitration agreement. And in-time application of the Section 67 involves a full rehearing, and I think that's important to stress. It's a full rehearing, and then case related to Pakistan that's I would highly recommend to having a look at judgment of is Dala Real Estate and Tourism Holding Company against the Ministry of Religious Affairs, Government of Pakistan, 2010. It's I'm happy to share it later if anybody's interested, and it's that the court has the power, that it was confirmed by the Supreme Court that the court has the power to confirm, vary, or set aside the award in whole or in part. So there will be a full rehearing, and then the court can decide whether the whole or the part of the judgment or the award should be set aside or not. And Another case I wanted to mention is Enka Insat v. Sanai AS against insurance company Chubb in 2020. And the Supreme Court held there that if parties have not specifically agreed on a governing law for the arbitration agreement, the following principles will apply. When the arbitration is contained in a wide contract, and the parties have chosen a governing law for the wider contract, the arbitration agreement will generally be governed by the same law. If there is no such provision, then the system of law in which it's most closely connected to will apply. So that's section 67. 68 is for serious irregularity affecting the tribunal, the proceedings or the award. And I think this is most relevant to our discussion, because this is where one of the grounds is where the tribunal has failed to comply with general duties. There are a couple of duties, and one of them is to act fairly and impartially as between the parties. And again, there is a lot of case law on that, but I won't list that now. And finally, one can try and challenge an award under section 67, which is an appeal on a question of law.
Absolutely brilliant. I'm going to come to Majid Khan now, and my question to you is from the perspective of, in 2011 we have an updated Act, Recognition and Enforcement of Arbitration Awards 2011, REACT. How has life changed since the Act has come in force in Pakistan, in your experience, because it's international awards recognition?
Well, to make it simple, the thing is that with this enforcement, we have with this 2011 Act, we have skipped the civil court part, because
Okay.
under the 2011 Act, the award comes directly to the High Court, and we lose the opportunity to play with the award in the civil court. So that is the major thing, and just because of that, the award is much enforced much quicker than as per the previous law. And other than that, I think we don't have much room to play with for the enforcement. We don't have much room to file the objections and all that. And because of that, it fairly quickly enforced. But again, there are about, I think, 8 to 10 awards that have been filed in the High Court. But for some odd reason, they have not been enforced as yet. So that is, again, the system that we have. And until and unless we do something with the system to improve the enforcement, the law is there, but the system is not supporting it fully. That goes for both the sides. Like, if the award is in your favor and you want to have it enforced as quickly as possible, then you have a problem. And at the same time, if you are on the other side, if it's against you, then although you lose the civil court, all the time that you could have you wasted or whatever, you can say in your favor. But again, the High Court is not, I would say, not that efficient the way the law provides it to be for the enforcement.
So that's interesting and exciting to hear that there is an efficiency in terms of pro arbitration and enforcing of international foreign awards, but then what it is doing is providing less opportunities for challenging the award. And Ali, is that kind of the right conclusion towards it? And what's your experience in that regard?
You have perfectly said it, because what's happening these days, our courts, and there is a recent judgment, 2022 judgment in Pocoso case, POSCO case where the Lahore High Court has held that if you are challenging some part in the civil court, that is not permissible. And every challenge, everything has to be brought before the High Court. And now the complication is, if I'm having an award in my favor, and there is nothing which requires any further execution. For example, if a decision of the government was challenged and that judgment or order has been set aside in the award, and I do not need it any specific enforcement, I'm not going to file the enforcement petition. Now, if the other party, who is the award debtor, intends to challenge that, they have no place to challenge. The only thing they could have done was to get it set aside, but they can't do that. So,
Yeah.
applying the New York Convention in stricto sensu lessens the room for the aggrieved party. First thing, this is how the things are happening. But second thing is, when the High Court permits the party to file the objection and the objections are filed and they are supported with the documentary evidence, I can see even the High Court going into that area. Where earlier under the 40 Act, even the civil courts were prohibited to go. So this is yet another area of difficulty. And some benchmarks, some lines, some separations should be drawn clearly. One thing more, which I have experienced recently, there are three major judgments from the Lahore High Court. One is in Shakkarganj case, one is called this POSCO case, which I referred earlier, and one Orient case. And then the Orient judgment was upheld by the Supreme Court of Pakistan. Some or the other, I was a representative of one party in Orient, and I have been in the other case of Kake as well, which had some international fame as well. So my experiences there was that when the matter after award comes to the court, our judges are of the mind that now there is an international award and we have to implement it at any cost. So there, the opportunity with the other party is a bit restricted.
Absolutely. I mean, I'll just give my little perspective on it. So I'm the numbers person, and I look at statistics and data, and as doing few arbitrations and things like that. Once the arbitration award is done, the arbitrator is out of the way and leaving it to the councils and the parties to enforce the award, challenge the award, do whatever with it. There was Queen Mary does this annual survey on arbitration. So I'll give you some stats from the 2008 survey. 75% of the arbitration awards, the parties recognized and enforced it without going to the court. So they just had the arbitrator award and they just dealt with it. Whatever the arbitrator said, either I pay, you pay, this is what the award has said. 75%, that's a very high percentage. Say 10, 15 years on, do you think the number is the same? The correct answer is we don't know, because they haven't done the survey in that same way again. So we can't really say statistically that is the case. But then I looked at a number of, news headlines. You might have heard some of these, like Uganda fails to knock out rail claim. Iranian state entity fails to overturn €1 billion award. US Supreme Court rejects Petrobras bribery appeal. Spanish court sets a high bar for award scrutiny. The Dutch court refused to stay the UCOS award. Pakistan tried so much on the Rico Dig award to have it set aside. All of these were rejected. In the end, they went to do settlement and things like that. So as you are saying, Ali, challenging an award is becoming more and more difficult. And this is where I'm going to come to you, Laura. Is it because the awards are delivered in a very tight scrutiny, or their quality is so high, or what's in the background that there is such difficulty to challenge an award and enforcement becomes more and more easier?
Yeah, that's a good question. Part of me wants to say, and it's counterintuitive, is that because your survey is from 2008, and so
Yes.
then we had the big crash, and then we had the recent climate after coronavirus. I would be really interested to see what the hidden statistics are. But at the same time, I'm going to say now going to the opposite direction. I think that so the decisions in the latest cases demonstrate that especially English courts, in terms of enforcement, have a very rigorous and robust approach to arbitrator challenges in line with courts' non-interventionist and pro-arbitration stance. And this is the thing, that the idea is, because why do we have arbitration here? It's an alternative to litigation. So if we put such extreme constraints by the court on arbitrators, then one could argue, what's the point? So there needs to be the thought process is there needs to be some detachment from the courts. Of course, the courts can intervene, but they really think very carefully when it's appropriate to not jeopardize the whole arbitration optional system that we have in place. So and in the case of Halliburton and Chubb, for example, the Supreme Court noted that challenges to of this kind, as in arbitrators' impartiality, have very rarely succeeded, and also noted that the objective observer at the heart of the appendant bias test will be alive to the possibility of opportunistic and tactical challenges. And this is another problem, that you have an arbitration award, it's a genuine award, and then a party can come and the unsuccessful party will try to challenge it just to challenge it, so that they don't have to comply with it. So one has to be careful about the tactical aspects of it as well.
Brilliant. Now I'm going to move towards, concluding type elements. And one of the things that I really wanted to discuss with all three of you is your experience in both domestic and international about the soft law around arbitration in terms of arbitrator ethics, in terms of IBA guidelines, or Prague rules, or whatever people want to follow. What's your experience in that, and how, Ali, I'll start with you from your perspective. Are you seeing those followed in Pakistan?
Well, truly speaking, no, because we have our own legal ethics for the lawyers. When the arbitrations are being conducted by the chartered accountants or by the engineers, they do follow their own system, own rules, but there is no general standard which is universally applied. And some of our participants today belong to Chamber of Commerce, and I must say that as a part of ciarb's mandate, we were urging them to allow us and promote more and more this arbitration process, capacity building, so that these soft laws should come in routine and people must implement it. But at present, they are not.
And so Majid Sahab, when you're appointing your arbitrators, what are you looking in them from that perspective?
First of all, like in our arbitrations, as I mentioned earlier, we have not done any local Pakistani arbitration, or we have conducted LCIA and ICC. And in those arbitrations, the arbitrators are selected by the forum, and they're just like imposed upon us. There's nothing much we can do about that. We have in our power purchase agreements, we have prior to arbitration, we have an expert determination also. And at times we take the disputes to the experts, and while selecting an expert, we normally tend to go for retired judges, preferably from Supreme Court or High Court, and we appoint them as an expert to give us a legally sound and enforceable sort of a determination. And other than that, the rest is with the LCIA or the ICC. Majority is LCIA. So we don't have any role in appointing an arbitrator under the arbitration, the LCIA or ICC.
That's brilliant. That's brilliant. And Laura, from your perspective, as you mentioned earlier, serious irregularity, which is, the general duty of the tribunal to act fairly and impartially. what have you seen changed in arbitration awards in this regard? What is the difference that I want to know is from an ad hoc versus institutional perspective in that aspect? Is ad hoc a bit more cowboy stuff and institutional a bit more regimented? People always ask that question.
So, of course, if you have an arbitration under, for example, LCIN or ICC, the encouragement for certain types of behaviors and approaches and to act fairly, partially, independent, all of that. And you've got the ancestral code, of course, model law falling into that. It also is very, very, very helpful and encourages good behaviors. Ad hoc, I think, yes, I think there is a little bit more scope for different types of behaviors. But then again, to answer, to tie in your earlier questions about the IBA guidelines, they are very persuasive. So if you actually, if you decide to, they are not compulsory. So you can decide not to follow them at all, to completely disregard them. Sure. And then you come to the enforcement stage where it comes in front of the court. And the court will compare the behaviors to the IBA guidelines and say, well, this is unacceptable. So, or not, depending what the court says. What I'm trying to say, it's not like one can just do anything and it will never be scrutinized. It will be scrutinized. So that's my personal view. I will tie in the official also from the, again, Halliburton Company and Chubb Supreme Court decision, where the court actually said that the IBA guidelines, and I quote, assist the court in identifying what is an unacceptable conflict of interest and what matters may require disclosure, but emphasize that they are not binding. So this is the state of affairs. I think some sort of flexibility is good to have, but at the same time, proper behaviors are required, because at the end of the day, if it comes to court, it may have serious repercussions.
Brilliant. And just lastly, we've discussed, REACT, New York Convention, grounds of public policy, and things like that. We are still seeing arbitration awards being challenged on such grounds. Ali, on domestic arbitration, can you have a challenge on the grounds of public policy?
No, because public policy is not a ground which is available under the domestic law. I think this ground is specifically now reserved with the New York Convention Awards.
Yeah, I mean, this is also interesting because when you look at the model law and you look at the New York Convention, neither of them actually have a definition of what public policy is. And they have left it open for public policy to be defined by each state independently of what public policy means to them. And again, from model law and New York Convention perspective, it's very much an international arbitration thing. Not in the perspective of domestic. And this is, one of the comments and questions that I have at the moment is, in Pakistan, regardless of the quality of the award, merits of the award, or anything, it will be challenged. Is that the case?
Not exactly. There are many awards. Look, understand there are two things to be understood first. First thing is that when the government is your other party or the contesting party, they do challenge. Even without reason, they do challenge. Because they have other fears of accountability, and they are bound to reply to some other authorities. So they challenge it, perhaps to save their own skins. But that is not exactly the case in commercial arbitrations, in private arbitrations. And my experience is many of the awards are even not challenged. May I add here, Arbitration
Yeah.
Act 1940 specifically provides in its first schedule that an award issued under the local law is going to be final in binding, unless it is objected under in writing under section 33, and the court allows that.
So I'll give a perspective of our neighbors because we've got to discuss that. So jurisdictions like India, and I'll give another example like Hong Kong. So they have a different perspective. They have a domestic public policy concept in terms of recognition and enforcement of cases. And there is actually a very famous Indian Supreme Court case, which actually talks about that the public policy should be considered from the enforcement forum's perspective and not through a transnational definition of the concept, as the latter was unworkable. And then the Hong Kong court has actually shared similar views, and they've defined an award that violates public policy as an award that is so fundamentally offensive to the enforcement jurisdiction's nations of justice that despite it being a party to the convention, it cannot reasonably be expected to overlook the objection. Now, in the absence of such international arbitration law in Pakistan, although we have the recognition and enforcement perspective, but there is no such provision or public policy defined in that perspective, because some jurisdictions are clearly distinguishing between domestic public policy and international public policy. And I'll give another example of Portuguese law. They review foreign awards only from an international public policy, but their domestic awards are looked at from a domestic public policy perspective. I mean, each country is doing things differently. So in the absence of a definition of public policy, this posed a dilemma for Pakistan, or a challenge, or maybe an ease of doing business, that because there is an absence of it, nobody cares about it.
But Nasir, there is some recent development in it. The Lahore High Court, in two judgments, one in they wrote a passage in Orient Power, and then they wrote in POSCO case on the public policy. And one part of that judgment is that where the law of the country is violated in the arbitration agreement or in the award, then that is a question of public policy. And they agreed to the argument that New York Convention, Article 5 in specific I'm talking about, is constructed deliberately, that Article 5.2 is separated from Article 5.1. In Article 5.1, the onus lies on the party. But in Article 5.2, it is the duty of the authority or the competent authority or the court, whatsoever it is, in the relevant country to look, while remaining within their circumstances, that whether their public policy is violated or not. So that cushion was deliberately kept intact even in 1958.
Excellent. I'm now going to just going into conclusion mode. So I'm going to take it in turns and ask each of you from your perspective, just your concluding remarks in terms of recognition and enforcement of arbitral awards in Pakistan. If you can just do a concluding remark each, and starting with you, Laura, where do we see this moving forward, and how do you want to see it moving forward?
I think ensure that before arbitration starts, that the relevant arbitrator or tribunals is appointed properly, and that the IVA guidelines are taken very seriously in order to ensure that when it comes to the enforcement stage, that actually it will be a smooth process, a clear process. So that's one thing. That's it.
That's brilliant. That's brilliant. Ali, what's your view? Ali's gone.
That we can cover so many areas by developing the capacity. So that is the base.
Sorry, could you say that again? Because I think you were just cut off a bit.
Oh, I'm sorry. My point is that we need to develop capacity as people doing in this area. Why I'm saying this regarding the enforcement, as Laura just pointed out, starting from the appointment of the tribunal, going through the process, end of the day, you find that an award is set aside. I tell you an interesting point. Under the 40 Act, I was surprised to see when I read it for 20 years, I went to my teacher and asked, so what is this? And the point was that if an award has been remitted by the court to the arbitrator to relook into it and it's resent in specific time, and the arbitrator has not done that, the entire award becomes void and the procedure is liable to be set aside. The arbitration is gone. So that is what I'm talking about. Coming to the enforcement at the present, Majid has said rightly that since there are high courts which are more powerful and they are more, their directions are more serious one, so there we can see a clear increase in the enforcement and recognitions, and I'm hopeful it will go on like that.
Definitely. No, that's brilliant. Thank you very much. Majid Saab, your concluding remarks, please.
Well, in addition to all that's been said by Linda and Ali, I would just repeat myself regarding that enforcement process at the High Court level. If the High Court can have some sort of a dedicated bench or something like that for the enforcement of these awards, I think that would bring in efficiency and would finalize the things much easier and quicker.
I think that's a very, very fantastic point, because this is one of the things that the judiciary is actually looking at in terms of enacting commercial courts in Punjab, and now they're looking at commercial courts in Sindh High Court as well. And one of the key aspects is to promote arbitration, to promote ADR. New legislation has kicked in. At the Pakistan International Disputes Weekend, the chair, CIR Pakistan branch, Mia Shiraz, he proposed a new domestic arbitration act in Pakistan. So a new bill has been written. It's actually doing its rounds. There is a new committee set up by the current Chief Justice of Pakistan, Honorable Chief Justice Mr. Umar Ata Bandial Saab. He's formed a committee looking at all of these attributes in terms of updating not just the judicial system to become pro-arbitration in terms of recognition and enforcement, but also to support updating the legislation and the statutory instruments that we have in the country. So on that, I think in terms of where I would look at in my concluding of this webinar, I think it's a very, very positive outlook from an arbitration perspective. It's a very sophisticated regime that is in place both domestically and internationally. We do need to upskill our people. We do need to make them aware that arbitration is a resolution method available to them. We need to have more arbitrators in Pakistan. And this is where I think Chartered Institute of Arbitrators coming into Pakistan as a local branch, we've been 1 year on, is a significant step towards educating, improving, and training both arbitrators and the recipient of arbitrators. So that would be, I think, a fantastic viewpoint. And this would be really good. So only way is upwards and positive. I've just received a few questions, and I'm going to pick this one up. It's in the chat, not in the questions. Discuss the organization of Government of Pakistan named Trade Dispute Resolution Organization. I think need to know more about it. I don't know about the Trade Dispute Resolution Organization of Pakistan, so need to find out about it a bit more, so we can look into it. Yes.
Nasir, if you permit, I can talk
Yes,
something
yes,
about
please.
TDRO. This was being developed by the Ministry of Commerce of the Government of Pakistan. It was designed to be a purpose-built arbitral forum, providing the arbitration comfort to the investors and that particular side. So certain efforts were made a few years back. There was a lady who was doing all the stuff. At a specific stage in time, it turned out to be a futile exercise. And again, at like I think it was 2021 December, I think, if I'm not wrong, I was called by them, the GDRO people, and they told me that they are trying to reinvent the wheel and make new law and rules and regulations and sophisticate that system. But their problem at that time, at least, was that they was trying to link it only with the CPAC. And even in CPAC, only with the road initiatives. So they were limiting themselves, and I suggested them to wide open their doors, let the people come in, let the investors come in. And that would flourish their entire exercise. And I'm very happy to see this comment from the president of the Multan Chamber of Commerce, Mr. Khaja Mohammed Hussain, who is here in this panel at the moment, in this webinar. So I'll be requesting him as well to take the initiative, because this is the best thing for the investors in long run.
Absolutely. And anything that is supported institutionally, which is fantastic. And this is something that I would just like to, on this is from the perspective that CIAB rules guidelines is available for free. And we as the branch, so I'm the vice chair of the Pakistan branch. There is a lot of branch members. There's a branch office in Lahore who are all available to support and help people develop and move forward. So please do get in touch. And I really, really appreciate and thank you, Laura, Ali, and Majid for your time and for amazing discussion. And I'm hoping that all the attendees today have benefited from it. And on that note, I thank you all for attending and keep in touch. And we'll be back next month. Thank you.
Thank you.
Thank you
you.
very much.
Thank you,
Bye.
everyone.
Good day. Bye-bye.
Take care. And thank you, the worthy moderator.
Definitely.